introducing the moderator for today's panel.
General Counsel to Governor DeSantis, Joe Jaco. Now, yesterday when I spoke with Joe and I asked him, what of your many amazing accomplishments would you like the people of Florida to know about you, and what should I emphasize? What's that one fact that you want everyone to know? He told me without missing a beat, I like short introductions. So let me not let him down, and let me turn the microphone over to Joe.
I appreciate that. So last night before I introduced the governor, I looked at him across the table and he goes, "Joe, keep it short." So we'll keep that trend going. All right, for this panel on election law and redistricting, what I'm planning to do is I'm just going to go ahead and give introductions of each of our panelists at the start. They have up to approximately 10 minutes to give a perspective, and then we'll open it up for questions. I may have a question or two, and then obviously we'll take audience questions. So let me go ahead and kick it off with introductions of our panel. So to my right is Christian Adams. He's the president and general counsel of the Public Interest Legal Foundation, which is dedicated to election integrity. He brought the first private party litigation resulting in the cleanup of voter rolls under the National Voter Registration Act. Mr. Adams served as a member of the President's Advisory Commission on Election Integrity, established in 2017. And from 2005 to 2010, he served in the voting section of the U.S. Department of Justice. And he's the author of the New York Times bestseller, Injustice. Did you not know that?
Oh, I knew it.
Okay, all right. Okay, to his right is Kendall Coffey, who is a former U.S. attorney from the Southern District of Florida from 1993 to 96. And he's the most recently chair of the Southern District Conference, the Florida Federal Judicial Nomination Commission. He is a founding member of Coffey Burlington, concentrating on complex litigation, and he serves as an adjunct professor at the University of Miami Law School. And not only did Mr. Coffey have a major litigation role in the 2000 presidential recount, but I recall that he worked in tandem with some efforts that I had on Capitol Hill as he led the efforts in the Elian Gonzalez custody battle. I appreciate that. To his right, Jessica Johnson served as general counsel to the National Republican Congressional Committee in the 2010 and 2012 election cycles. She advised Republican members of the House of Representatives and candidates. She also created and managed the Volunteer Attorney Network, training attorneys for Election Day operations. She is of counsel at Holtzman Vogel and focuses her practice on campaign finance. And she received a JD from the University of Florida College of Law. Excellent. All right, and next we have Daniel Nordby, who is the former general counsel to Governor Rick Scott. He currently serves on the Florida Supreme Court JNC. And as many of you know, he served as general counsel in the Florida House and Secretary of State's office. He recently rejoined Schutz and Bowen as a partner, litigating in the areas of election law and constitutional law and administrative law. And just a special thanks to Daniel for making my transition very, very good. So I appreciate that. And then we have Mr. Chris Suter, president of Suter Communications and Films. He's a political media consultant, attorney, and filmmaker who has expertise in election recounts. He's also an adjunct professor at American University. He wrote the book on recounts, appropriately called The Recount Primer, which he co-authored in 1994. And in 2000, he played a major role in the presidential recount. Furthermore, he is in the filmmaking business. It includes two feature-length documentaries. One's called King of Steeltown, on Chicago-style politics in the Midwest, and the other, So Glad I Made It, about the struggles of a singer-songwriter. So I'm going to watch that one. All right, so let me turn to Christian to kick us off for this morning.
Good morning. Thank you very much, Joe, and what a great crowd. It's nice to see so many friendly faces and friends, and it's also very hard to follow that last panel, so please bear with me. My name is Christian Adams. I'm the president of the Public Interest Legal Foundation. It's a 501c3 public interest law firm. All we do is election issues. And what I was going to talk about today was a Florida issue that we were deeply involved in for a number of years that hopefully you'll get some real CLE knowledge out of this one. And it involves your former Broward Supervisor of Elections, Brenda Snipes. Thank you. I'm done. I had the pleasure, and what I'll do is I'll talk about some Florida law and that office and how it interacted, and really, you know, you had such a close election here in Florida. When you see election results like that, and you match it with what I'm about to tell you, I think all you can do is sort of shake your head and just hope that things improve now that she is no longer in that office. I had the pleasure of conducting about a 5-day trial with Bill Davis, a partner or a former partner of Joe's at Foley and Lardner down in the Southern District of Florida, against Dr. Snipes. She was the defendant. The plaintiff was another 501c3 charity. And it was based on the National Voter Registration Act. Now, all of you who want to get involved in election law should know a little bit about this law because it was passed in 1993. You all remember Motor Voter, and it's really called the National Voter Registration Act. And it does a couple of things, but two things that are important for this morning is, number one, it requires election officials to reasonably maintain the voter rolls. Okay, that's the operative word, reasonable. Okay? The second thing it does that you may find of interest someday in some use is it gives you this amazing right of public inspection. You all thought Florida has a great sunshine law, right? It's probably the most incredibly powerful FOIA law in the country. But there's something even more powerful, and that's the public inspection rights under the NVRA. If there is an election record involving list maintenance, you have a right to physically inspect that record under federal law. This is not, please mail me back photocopies. This is walk into the office and start thumbing through records, okay? It was put there primarily to help groups like the ACLU, the LDF, all of the usual suspects who wanted the 1993 statute, but our organization has now started using it to do deep dives into election administration. So let me tell you about the trial with Dr. Snipes. We alleged that she was failing to reasonably maintain the voter rolls. Now, what I'm going to talk about is some evidence and some law, and I'll try to mix the two together, so I think it'll keep it somewhat interesting. Let me talk about some of the evidence that we found in this case because of our deep dive into her voter rolls using Motor Voter. For example, there were 7,635 New York residents who were registered to vote in New York who were also registered in Broward County. 7,635. Obviously, New York is not the only state this is happening from. Some of those people were, in fact, voting in elections. The other thing Dr. Snipes did is she registered over 1,000 people at commercial addresses. Florida has an absolute prohibition in statute of registering people to vote at like UPS boxes. And that has a redistricting implication. You know, you're supposed to be redistricted where you live. And she registered over 1,000 people at commercial addresses. When this violation of federal statute was brought to her attention, Dr. Snipes' solution was to simply, in Moss, move all of those commercial addresses and move the resident's address to her office, where, of course, nobody lived. And nobody would even know that it happened, for example. Your registration address was just moved. I actually got to do 2 depositions with Dr. Snipes, which is extraordinarily fun reading, and if I had an hour instead of 10 minutes, you would see a big screen up here with some great quotes. But alas, I don't have that. What's interesting about the depositions of Dr. Snipes is she didn't know a lot of this stuff. Like, she didn't know the statutes. She didn't know, and I'll get to the particulars in a moment, what some of these were. Now, those of you who have followed along with the news know that she also mailed out voter cards, registration cards, to the incorrect address. In other words, the name was one, your name, but your cousin's address, for example. So there's a mismatch on those. She mailed over 1,700 of these to voters in Davie and Cooper City. She printed out a ballot. You had a ballot referendum here, as you guys all know, since you vote here, how long they are. And it was in Haitian, it was in Creole, and she substituted on the ballot the word yes for no. And so it was literally an inversion of the results on the ballot. It was one election, she just didn't include the medical marijuana referendum on the ballot that was printed in Broward County, just omitted it. Florida requires, the Secretary of State requires certifications that she's doing certain things under Florida code. And this was fascinating because when we asked for these records, she said she wasn't doing all of these things. In other words, we got the records that said she was not doing them, but a week after we did her deposition and confronted her with these records, she did amended certifications that went back, related back 7 years, that said, oh yes, I have been doing these things. Look, it was chaos. The office was in a state of complete chaos. But we also had discovery abuses in the case that I've never seen before. Things like my expert wanted to know, do you have manuals how to do list maintenance? They said, no, we don't have any. And they didn't have any until they found them on the third day of trial, which required me to do a deposition in the middle of the trial about the manuals. And the reason that the lawyer told, this is what happened at a sidebar, the lawyer for Dr. Snipes told the federal judge that she learned about the manuals about a week ago, before the trial started, but she was afraid if she saw them, she would have to turn them over to us. I don't know if there's anybody here on your discipline committee, but you could look at the pleadings and the transcript and see all of this. Let me talk about some of the law, and that you guys have a fantastic law in Florida. Fantastic law, one of the best in the country. It was enacted a couple of years ago. It's Florida Statute 98, 045, 065, and 075. And hardly any states have this. Let me just run through some of the things. Your election officials are allowed to use out-of-state voter registration information to clean up their rolls. So if you're registered in New York, you're allowed to look at that in Florida and say, ha ha ha, you're registered and voting in New York. You shouldn't be here. You can use jury notices. Remember, if you get out of jury duty because you're not a citizen or you're dead or you no longer live here, that's helpful information to an election official. And your legislature said so and passed a statute, which is 98065, that you can use jury information. Well, I don't need to tell you that she wasn't doing this. And not only wasn't she doing it, she didn't even know about it. That's what was so amazing in the deposition. She didn't know about this stuff. Obtain and use information from other sources is another statute. It's an omnibus provision that allows you to really keep your voter rolls clean. She didn't use anything. Remove registrants based on information from other sources that weren't in the statute is something that other election officials use as tools to keep their voter rolls clean. Now let me wrap by telling you what happened. The standard under the National Voter Registration Act is undefined. This was the first trial on this statute that was 20 years old. And the statute says reasonable list maintenance. And the defense of Dr. Snipes was, and by the way, this is on the 11th Circuit, what I'm telling you, for arguments in 2 months. What Dr. Snipes was saying is that, only look at if we do something, not how we do something, right? Our theory was if and how are both relevant. If you were doing it and how you're doing it. And Snipes' defense was, well, if we are doing something that is named in the statute, which is namely postcard mailings, okay, there's one little safe harbor provision in the federal law, and it doesn't matter how we're doing it, then she said that she's absolved from any liability for reasonable list maintenance. Our argument was that Congress putting the word reasonable in allows a more holistic analysis of your activities. So this is before the 11th Circuit, and I will tell you, oh, by the way, Judge Beth Bloom ruled in favor of Dr. Snipes and said all that matters is if, not how. So you're stuck now, or at least you were stuck, with an election official, and by the way, you're stuck possibly in the whole 11th Circuit if she prevails, which is why I'm hoping that this change in administration will result in a reassessment of whether or not you want to curse the entire 11th Circuit with if is all it takes. If you do two small things, you're absolved under a law that Congress clearly meant and intended to clean up voter rolls around the country. So thank you all very much for your time.
Thanks, Christian. All right, let's turn to Kendall.
Well, thanks very much for inviting me. And I really appreciate the interest in a diversity of perspectives. But I do want to say one thing that I think we all can agree with. What great selections the governor made to the Supreme Court of Florida. And Brenda Snipes, please enjoy your retirement. What I'd like to talk a little bit about is just the broad category of election crimes. Because as we've seen the whole election process get lawyered and lawyered more and more, some of the dimensions that are getting more attention are indeed with criminal investigations of election matters. But I can tell you that they, in my opinion, are going to be increasingly important. They rise in a couple categories. One of the areas I've seen most commonly is with voter registration, where PACs go out. They have people that are hired on a more or less temporary basis, sometimes incentivized to get as many voter registrants as possible. And there's some mischief there. And that's certainly an area of concern. And it can be ordinarily a federal crime because somebody being registered on the rolls is necessarily going to be able to vote in federal elections. So that's something to keep an eye on. Obtaining and marking ballots illegally, there are certainly anecdotally evidences and incidences of that, but it tends to be isolated. And I don't know that there's statistical evidence on the pervasiveness of that, but it's there. And there's other categories too, including election finance, which I want to talk about in a little detail. But the perspective that I think the Department of Justice is expanding on, and of course all of you who are leaders in the law can have influence on this, is that election crimes not only tarnish the sanctity of a democracy and can contaminate and even skew the results of an election, but they believe that election crime is driven by a motive to control government power for a corrupt purpose. And so that corrupt election practice lead to corrupt politicians and corrupt government. And in some ways, election crimes are more accessible for investigation purposes than a quietly engineered bribe in City Hall. Because election crimes occur largely in public. It's a public process. It takes usually to have much of a successful election crime, it takes a lot of people, including people that are just hired for the case. It's much more vulnerable to investigation than other kinds of crimes which may only occur in the corruption context among just a very, very few people. And of course, election crimes involve some form of paper or electronic trail. So the Department of Justice, I think, wants to do more and should do more because everyone here deeply cares about the sanctity of our democracy, and all of us appreciate that no level of fraud is acceptable. But it's difficult, it's challenging, and they, of course, have great sensitivities, as we've all read about interfering with an election outcome. And that adds to the challenges, because if you've got active, fresh evidence of something going on in the run-up to a campaign, what do you do about it? The minute you start interviewing people, of course, that hits the public. And often, of course, sometimes candidates will very loudly proclaim that they're delivering a file filled with corrupt evidence to the FBI and that their opponent is being investigated. And of course, the FBI in that situation would want to push back, but it creates very significant challenges. The other point I wanted to make is just to talk a little bit about campaign finance crimes. They are specific intent crimes, and that's different from the general intent crimes, because with a specific intent crime, you have to know that what you're doing is unlawful. And I hope there will not be a push toward campaign finance crimes, because they're treated very, very effectively through the Federal Elections Commissions with fines and administrative results. And ultimately, they become an area where a lot of attention and time can be spent with a case that's very, very difficult to prove. Just to give you a theoretical example, someone running for president has private money paid to a private person to avoid bad publicity. Is that a campaign finance crime? Well, it was attempted. The case blew up as an embarrassment for the Department of Justice. John Edwards was acquitted on one count, the others were hung, and multiple sources described it as a public embarrassment for the Department of Justice, that others called it a black eye for the Department of Justice, simply because it didn't have the elements of a truly prosecutable crime. So my perspective for what it's worth to part is to bear in mind that campaign finance crimes are specific intent crimes. The jury would literally have to be instructed, not just that the person did something they knew was wrong, that the individual did something they knew to be unlawful. That's a tough burden. So in that category, I would hope there's less government intention. In all events, there's no doubt that more money is being spent on campaigns every year. The stakes get higher, the elections get closer. Those are all the ingredients to increase the risk of election fraud. And I know all of us in this room are determined to do everything we can to make sure that doesn't happen. Thank you.
Thanks, Kendall. Jessica?
Hi, thank you all so much for having me. This is ironically my first Federalist Society event, so it is a pleasure to be here with you today and speaking with everyone on this panel. I also feel a little silly talking about the recount because you all lived it. You're Floridians. You lived it every day for that period of time, and then a lot of you also in this room specifically were very, very helpful and joined the team, and so you might know some of these individual stories much better than I do. But with that disclaimer, as Joe said, I do practice campaign finance and election law in Washington, D.C. I just finished my 10th year, 5th election cycle serving as general counsel at a national political party committee. And I have to tell you all, for an attorney, it is truly what I believe to be the best gig in the world. My job every day was to beat Democrats, which was, winning is great, so it was especially fun when we won. But, I got to do so using my law degree and doing something that I'm very passionate about, especially on the Republican side. So it was a great gig. Looking forward to the next chapter for sure. But this November, most of my colleagues in DC on the election law bar were, recovering from the election. They were preparing for the next Congress. And I suddenly found myself in Tallahassee, preparing for a statewide recount in the state of Florida. Now, as a Floridian, I'm from Sarasota. I feel like I kind of have a right to say that, things are a little different in Florida. I told everyone that in DC that I could say that, and they couldn't. But I knew I was in for it. My first job actually in politics was working for Katherine Harris. I was her communications director and had come in right after she had finished the 2000 recount. So, I knew a lot about what happens after a recount, especially in the communications area. And so it was sort of interesting to be living this on the front end this time around. But I wanted to talk to you today about some things which you, again, know very well, but that I think are very important for us as we consider 2020. I think as election law practitioners, we have to always be, the minute the election's over. So on November 7th, we need to start thinking about, what we've learned and how we better prepare ourselves and our clients and our candidates, our party committees for 2020. I think that is certainly true after a recount and certainly in a state like Florida. It will be no surprise to any of you, the number one thing I learned is that, malfeasance and incompetence are very dangerous when, done by election law officials. That was on full display here, particularly in Palm Beach and Broward, which is what you read about most often, but not only in Palm Beach and Broward. It wasn't until 4 full days after the November 6th election that, the party committees and the candidates even started to have an idea of how many ballots were left to be canvassed. And there's a state law in the books. And, I would echo Christian's comments. I mean, having, read recount laws and election law codes, my whole career, but in the months, especially leading up to the election, Florida's law was pretty fantastic. And I think that's really important to know. It's not something that you would have seen reported in the press. It really was, had been tried, obviously, and tested, and then specifically with respect to some of the litigation that we faced, in 2016 even, with the provisional balloting and the signature matching and opportunity to cure, that had all been tested in 2016. So this wasn't a failure of the law, in my opinion. There's certainly always, recount laws are so infrequently used, there's always things that can be bettered, and that you don't find out, unfortunately, until you're practicing and dealing with them. But this wasn't a failure of the law. This was truly an exercise in gross malfeasance and incompetence, for sure. So again, we didn't know for 4 days after how many votes had, even been left to be canvassed. And the state law provides that, we're required to be told that 30 minutes after the polls close. So, if you were wondering, why people kept saying, well, ballots are appearing, well, imagine you're told one number, you're not told any number, and then all of a sudden the number jumps, and then the number jumps again, and the number jumps again. It certainly did appear that ballots were appearing. Frankly, I'm not sure that we'll ever know, how that happened, but suffice it to say, and on election night in D.C., this was not a race I thought was going to a recount. There were several others sitting at the Senate committee that I thought, were likely going to a recount. It wasn't this one. So that was, something very frustrating that we had to deal with. Brenda Snipes also admitted to mixing 12 invalid ballots with over 200 ballots that were yet to be canvassed. Unfortunately, at that point, they'd all been separated from their envelopes, and obviously it's a name-blind process. So there was no way to figure out which ballots, were valid and which ballots were invalid. We didn't want to strike ballots of valid voters, so you just have to move forward there too. There were plenty of times where we had our observers sequestered behind glass partitions, set in different places where they couldn't hear or see what was going on, which is a right that is for sure afforded to them under the Florida statutes. And so, we unfortunately would have to sue in that instance just to get the access rights that we were guaranteed under law. The NRSC and the campaign, and on that note, I do want to say, the state and the now governor's team, were invaluable partners in this. And if you don't hear me saying that, it's just because they weren't my clients. So I just want to make sure that I'm being clear about that. This was for sure a team effort on all accounts. But the NRSC and the campaign filed several suits over the course of this, what felt like months, but I guess it was really about 8 days, demanding access, demanding, that the process be protected. Particularly frustrating to me was the impound orders that we filed. That is a very routine pleading in election law. You have those drafted in every state, that you have an election and they are ready to go. But somehow in the press, it was made out as if we were actually asking to take possession of the ballots or roll in there and actually physically touch them when we filed these impound orders, which was not at all the case. We were asking that law enforcement get involved to help protect the chain of custody of these ballots, so we knew, where they were going as they were coming to the tables. We knew who was touching them. There was a back door at the counting location in Palm Beach that we had photos of that was swinging open, from time to time, and volunteers were leaving and coming, and we couldn't see the volunteers and what was in their hands. We were asking that law enforcement protect that back door and make sure they saw who was coming in and out of that. But suddenly that, was something that we shouldn't have been doing and very controversial in the press. So bottom line, the suits that I felt like we were filing were unfortunate because we were filing to protect the access that we were granted under law, but I was very proud to have filed them, and I'm going to have done exactly the same thing today. On the other side, the suits that we were, finding from the Democrats were not quite the case. By our count, and forgive me if I'm incorrect because this was all happening very quickly, and I will look forward to unpacking this for months to come, but by our count, there were 9 federal lawsuits filed in 8 days. These lawsuits, by and large, were to change the rules of the game after the election had already played out. For example, the one that is still going on in the 11th Circuit right now, the Dems filed a lawsuit asking to count and canvass and then count the valid ballots for all ballots that had been deemed invalid due to signature match issues. Again, this process in 2016 was looked at very intently as a result of other litigation in the state, and the amendments that were made, of course, were not challenged at that time. The Democrats were perfectly fine with this process up until November 7th, when they realized they were over 12,000 votes behind. But then it was very egregious and suddenly unconstitutional. And so they wanted all of these ballots to come back in and be canvassed after the law had been followed and they had been deemed to be invalid. So we obviously challenged that. We lost in, Judge Walker said that the signature matching process was conducted by laypersons, and therefore, I guess that wasn't, enough. And that people didn't have enough notice to cure their defected ballots. So there was a point at which, people who were belatedly noticed were provided additional opportunity to come in and cure their ballots. Didn't obviously result in much of a change, but I think this signature match process and the provisional ballot process is something we're certainly going to have to look at as we near 2020. Interestingly, in Arizona, Mark Elias, the Democrats' premier attorney, was making the same argument that we were making in Florida, he was making in Arizona because they were ahead. So, I think, and that was really fun to discover that. I'll never forget that particular moment. But, I think that's something that we're going to need to really look at, and we're going to dive into these, across the country, but especially in Florida. And I know y'all are already starting to do that. The signature match process when it comes to provisional balloting. We also saw lawsuits to extend the absentee ballot deadline. There was the incident in Opa-locka in October with the bombing threat, and all of a sudden, again, it wasn't a problem before November 6th, but all of a sudden there seemed to be some sort of question as to whether ballots were delayed and not received, and whether there were any ballots there. I think somebody at one point thought they found a box, but they hadn't. So that there was a suit to change the absentee ballot deadline in the wake of that. I'm looking forward to our judges across the country, ruling that they need to enforce these deadlines. These aren't suggestions; these are hard deadlines. And if there's a problem about that, I feel like now is the time to discuss that, not in the wake of a very close election. I think my personal favorite lawsuit was the one we saw in Palm Beach, where they just wanted to, instead of counting only over and under votes, they suggested that we just recount everything in the hand count. Just everything, not for any particular reason, but just why not, let's just recount everything. So that, thankfully, that did not go forward, and I also will remember that moment as I think the moment that we knew that this thing was over, and I think the Democrats knew that too. So, I think for me, again, so much to learn here. I really look forward to unpacking this, and I do feel like we really were seeing sort of the Democrats' playbook as they head into 2020, and I look forward to teasing that out and figuring out how we move forward and train our people and prepare for 2020, which I think will be obviously a very pivotal election in our country. But for me, I think the one thing I learned is that, we have to be in the position of protecting the law and standing up for the access, the transparency, the ballot integrity that we know is afforded under these laws, and then obviously strengthening the laws where that's not the case. And then, we have to continue to push back against these lawsuits that we'll face to move deadlines and change the rules of the game after the elections happen. So thank you very much.
Thanks, Jessica. Daniel?
Well, thank you, Joe, for the introduction, and thank you for your service as well for Governor DeSantis. He has, as we've all seen, maintained a relentless pace over his first 3 weeks, and I know that means his legal office is working at least as relentless a pace as he is, so thank you for your work. And thank you to the Federalist Society. When we had our first conference over at the Swan and Dolphin a few years ago, I don't know that any of us could have imagined where we'd be here at our 5th annual conference, the size of the audience, the speakers we've had. I always love speaking at Federalist Society events, and I think it's a real credit to the quality of the group that brings in wonderful panelists on interesting topics, and an audience that comes here on a Saturday and is interested in engaging on big questions like this. So thank you again. I'm glad to participate. I'd like to speak today about some of the challenges that we faced here in the Florida 2018 election from the perspective of the state government, which is where I was working this particular election cycle for the last 2 years. and pose a few questions that maybe we can get into through audience engagement and some of the back and forth on where we go from here. The first challenge that we faced, which has in some ways has almost been forgotten because I think we handled it well, was a natural disaster that we had less than a month before the election. Hurricane Michael formed and 3 days later hit the Gulf Coast as a major Category 4 hurricane, made landfall on October 10th, less than a month before a statewide election. It was still a Category 3 hurricane when it left the state of Florida, and I think it still had hurricane force winds by the time it got all the way up to southern Virginia. So it was a major storm, devastating effect, about 2 weeks before the scheduled start of early voting. I'm working up a little bit of a case study on this for people to look at in responding to future disasters, because this is the nightmare scenario when you're looking at potential election emergencies, is a hurricane hitting the state of Florida right before the election. So 99% power outages across a huge region of the state, a lot of counties that are rural counties without large supervisors of election staff. And after dealing with human survival needs, we quickly realized that a massive effort was going to be needed to have a successful election in that area of the state. So we talked to some people that had gone through it before. New York and New Jersey had Superstorm Sandy back in 2012. We learned from some of their experiences, put together some recommendations from what they had done, presented those to Governor Scott, and then I think worked really well with the lawyers for both the Republican and Democratic parties in the state about what ideas Governor Scott was planning to do to help people vote in these counties, and I think they were actually implemented to a large degree successfully across those counties. Work with our partners in the telecommunications and electricity industry as well to have functional voting sites at all of these counties, and everyone was able to vote. Governor Scott exercised some of his emergency powers to make accommodations in the 8 hardest hit counties for extra days and hours of early voting, some flexibility on sites, some polling place consolidation procedures, and those counties and the citizens of those counties, to their credit, they really turned out. They turned out at a higher rate than a lot of other areas of the state that hadn't just gone through what they had gone through. So I think that's a real success story. It's a challenge that I think we overcame as well as we could this past election cycle. The second challenge that Jessica's already gone into a little bit is some of the litigation. And let me be clear about that. Litigation itself is just part of the process, and there is an entirely appropriate role for judicial intervention in an appropriate case or controversy. It can be vital to ensuring that elections are conducted in a transparent manner and making sure that the laws governing the process are followed. Justice Lagoa, at her announcement at the Freedom Tower, spoke very eloquently about the consequences that can befall a nation when the rule of law is disregarded and when the judiciary will not protect the rule of law and ensure that the laws are followed. So the litigation challenges that I'm referring to, though, are a different kind of challenge, and ones that we saw in this cycle to a greater degree than any election cycle since 2000. It's litigation filed either immediately before or after an election, seeking to either enjoin the application of a longstanding statute ahead of time or declare a statute unconstitutional after the election has been held and change the rules of the game, as Jessica put it. So, for example, in late July of last year, a lawsuit was filed. There were 2 filed about the same time. I don't remember if this one was filed by either the Democratic National Committee or the League of Women Voters. They were represented by the same counsel and kind of operated in tandem on a lot of these cases. But this case that I'm referring to was challenging the constitutionality of Florida's ballot order statute. So in Florida, in every partisan race, the same party is listed first for that race, and it's governed by the party of the current sitting governor of the state. So this year, in every partisan race, the Republican candidate was listed first, and then the Democratic Party candidate, and then the minor parties going on after that. Now, maybe that's the best way to deal with it. Maybe it's not. Some states do it alphabetically. Some states do a random switching of the parties, race by race. There's different ways that different states do it. But my concern with this litigation that was filed at the end of July is that this wasn't some scheme that Governor Scott had cooked up. This was a law that had been enacted nearly 7 decades ago by Governor Fuller Warren, had been on the books, had actually, it just so turned out that it had benefited the Democratic Party and the Republican Party equally in statewide elections over the past 70 years, because each had controlled the governor's office for about the same number of elections over that time period. And their theory was that the candidates that are listed first have an inherent advantage because, I guess, voters who don't really care who they're voting for tend to vote for the first listed candidate to some percentage a little bit higher. There's conflicting expert evidence on that. But my concern on it was with the timing of it. It was a lawsuit to a law that had been around for 70 years, lawsuit filed in late July of this year, seeking to overhaul a process that would lead to the printing of ballots that would have to get mailed out a month later, right after the primary election. I don't think that's the best way to have a thoughtful process on the constitutionality of a statute like that. We had post-election some similar challenges to longstanding statutes. In Florida, vote-by-mail ballots generally have to arrive at a supervisor of elections office by 7 p.m. on election night, except for UOCAVA voters, uniformed overseas citizens, have a little bit of extra time as an accommodation to their overseas status. That's a law, again, in Florida that's been around for a very long time, but there was a challenge filed post-election seeking retroactively to invalidate that statute and count ballots that had not arrived by the longstanding statutory deadline. Similar ones to the signature matching requirements, lawsuits challenging those, and lawsuits challenging the standards for determining voter intent in counting overvotes and undervotes. Now, that particular law and administrative regulation on voter intent on overvotes and undervotes was a subject of a lot of attention about 18 years ago after the 2000 recount, and Governor Bush's team and the Florida legislature enacted a comprehensive reform package for exactly how to determine voter intent. There's diagrams in the administrative code showing if you circle all of the names instead of filling in the oval properly, if you do it consistently on the ballot all the way down, then that's counted. If you do it this other way, those shouldn't be counted. And those rules were well known to everyone of all parties, but there was a lawsuit filed to throw that out. So I guess my general reaction on that, and maybe we can get into it later, is I think there's a real question about how courts should look at attempts to change the rules, especially after the election or on a purported emergency basis before the election. We talked yesterday in the stare decisis panel about some of the other considerations that go into adjudicating cases beyond the text and so forth. And I think in these sort of emergency situations and injunction situations, the equities and latches, I think, should be looked at and relied on to a significant degree. And people should know what the rules are going into an election and operate under those rules, unless there's some very good reason why a lawsuit could not have been brought earlier for some reason. And the final point that has been touched on a little bit has been election administration. We saw some significant challenges there. Fortunately, those I think were not really systemic issues other than a couple of our South Florida counties in Broward and Dade. One of the most important responsibilities of a supervisor of elections, I would argue the most important responsibility, is to plan for and conduct elections in such a manner that the public can be confident that their votes are counted quickly and accurately and transparently. I don't think that's in any way a partisan standard, and supervisors of elections from both political parties in counties, small, medium, and large, did that successfully throughout our state this past election cycle. But when the nation and the world looks at Florida in October and early November every 2 years, it sees what happened in Palm Beach and Broward County. The Miami Herald had a front page article on November 14th that I saved an image on my phone because I thought it perfectly encapsulated what we saw. And it said, I quote, "Dade finishes its machine recount as Broward starts process." That shouldn't be the case. And I think that does come down not so much to what the laws are, because Miami-Dade counted more ballots than Broward, more ballots than Palm Beach. It comes down to planning, comes down to management, it comes down to funding, which is a function of management and planning for those counties. And I am also hopeful that with the recent resignations of the supervisors of elections in Broward and Palm Beach County, with some executive branch encouragement, that we'll see something a little bit different in the next election cycle, and that we'll have elections that we can all be proud of, that were conducted in a quick and accurate and transparent manner. Thank you.
Thanks, Dan. Chris?
Well, happy Groundhog Day, everybody. I've often thought waking up during a recount of Bill Murray in the movie Groundhog Day, as each day repeats itself again and again. I want to thank the Federalist Society for inviting me to participate in this panel. This is my first Federalist Society event, and I have to recall the words of James Stockdale, who was Ross Perot's running mate. During the debate, the first words he uttered was, "Who am I and what am I doing here?" Well, my name is Chris Sauter. Among other things, I'm a Democratic attorney. I also have a political consulting firm, and a little-known fact is that I was Barack Obama's very first media consultant and wrote and produced his first ads. You can you can tar and feather me afterwards.
They were good ads.
I also have the distinction of having worked on both the 2000 Florida recount in Broward County and the 2018 recount. And I might say, well, I would say I worked for the candidate who did not select a cabinet. But I would also say that I noticed that, and I mentioned this to a reporter for Miami Public Radio, that my experiences in some ways were very different, because in 2000, Broward County was the one county that did it right. And they were the one county that finished the recount, whereas, has been pointed out, in 2018, they struggled mightily. I also worked in 2018 for the Senate candidate who subsequently had to vacate his office. But I did work, in addition, for Nikki Fried, who is the only Democrat to win statewide. So 1 out of 3 is not bad. I have been involved in election recounts going back 35 years to one of the most controversial recounts, Indiana 8, which was ultimately decided by 4 votes. There were 2 full recounts. It lasted 6 months, and it marked, that controversy marked the beginning of the rise of Newt Gingrich, for which I've had to explain to many of my Democratic friends and actually a few of my Republican friends. But I don't have the Florida experience that most of the people on the panel have, but as I mentioned, I've been in 2 statewide recounts. I spent the weeks leading up to the 2016 presidential election working in South Florida for the Florida Democratic Party, and I am counsel in a federal lawsuit that was filed in November, kind of under the radar, that I'll talk about in a few minutes. But first, I want to begin with a few observations as somebody that's coming in a bit from the outside in a number of ways. Just as Georgia was the national face of voter suppression, Florida was the national face in 2018 of troubled election administration. And there's no doubt that Brenda Snipes was the face of that troubled election administration, but she wasn't the only one, and Palm Beach wasn't the only one. And but we did, the experience did amount to a bit of deja vu all over again, as Yogi Berra used to say. Recalling 18 years ago, complete with blown deadlines, missing ballots, and a a ballot design that may have cost a statewide candidate quite a few votes. So there are a number of problems that I would just like to talk about that I think need to be addressed in some way, and I agree litigation should be filed early rather than later. And I wasn't involved in any of those lawsuits. Just a bit of, but there are a couple of things, points I want to make about the continued election administration struggles in the state of Florida. One is our counties are underfunded, and as we know, in some cases, we have incompetent election administrators. We need to, and this is not just unique to Florida, we need to start putting people in these jobs who have experience and who have credentials to run elections, not merely people who can win elections. And I might say, as probably most of you know, Brenda Snipes was actually appointed by Governor Bush. So it all began before an election. There's a lack of uniformity in procedures and practices, and in my opinion, Florida needs a more uniform set of procedures. It's really a hodgepodge that varies county by county. And one of the things that I noticed, having not been here for a recount since 2000, was I couldn't believe that the basic structure of recounts is the same as was declared in violation of equal protection by the Bush v. Gore court. You still have local canvassing boards adopting some kinds of standards, or at least making decisions on disputed ballots. And Florida really needs to look at a couple of states like Indiana, which was cited in a footnote in Bush v. Gore as a model, where there's one single body that reviews all disputed ballots, or Minnesota, which I was one of the attorneys for Al Franken in the Minnesota recount in 2008. They also had a single body. I think when you have that uniformity, you not only are consistent with the dictates of Bush v. Gore, to the extent that there are dictates in that decision, but I think it also helps in terms of the public confidence in the outcome. Partisanship remains at both the state and local level. Again, this isn't unique to Florida, and maybe Florida gets a bad rap because of Katherine Harris, but Florida is probably worse than some states. Having done recounts all over the country, there are many states, more than a handful at least, where the secretaries of state or the chief election officer, even though if elected as a partisan, administers in a nonpartisan way. And hopefully now with Florida having a Secretary of State coming from the bench, we will have in Florida a much more even-handed administration of the election laws. Another problem, by the way, which I meant to mention on the lack of uniformity, is that the Secretary of State in Florida has overall been overly passive. The Secretary of State really needs to take an active role in training the local election officials in a uniform manner, having more uniform statewide rules and procedures so that everybody is operating in the same way. Poorly written election laws, I think, is another problem. The biggest problem, again, having seen how other states administer their canvass and their recounts, is that there's not enough time for the big counties like Broward, Palm Beach, Miami-Dade. They're really under a lot of stress given these deadlines to be able to comply with the laws. That is one reason. Certainly incompetence has played a big role, obviously, in Broward County. But there's with the one thing that didn't exist in 2000 were all these mail ballots. And the mail ballot program, which I agree with because it makes voting more accessible, has put incredible strain and stress on election officials throughout the state, and having to deal with problems like signatures, mismatches with people who aren't really trained to judge those, and having to meet these deadlines, and in many cases they're not properly trained to begin with. All of those contribute, I think, to a bad situation and a potential problem in a state like Florida that's likely to be very important in 2020. Poor ballot design. I remember in being here in 2000 thinking to myself as the butterfly ballot debacle unfolded, well, looking for a silver lining, well, at least this will never happen again. It's really fundamental that you seal off instructions from the rest of whatever it is, whether it's a LSAT test or whatever. You're supposed to seal off the instructions. And I was in Broward looking at those ballots, and the office that's supposed to be at the top of the ballot was buried under a set of instructions in the third column on the left, and as a result, there were over 30,000 undervotes. And clearly, there's obviously no way of knowing what the impact might have been had there been a good ballot design. But obviously, it cost Nelson some votes, and there's no reason for it. And there really needs to be testing of these ballots before they're. I think what normally happens, talking to people, is all they look are for spelling mistakes, and they're not really doing a real test of whether or not there are problems in handling these ballots. That needs to happen. The Secretary of State needs to play a more active role in making sure that the ballot design is proper. We talked about the mail ballot signature mismatch has been talked about. My experience, and I've done recounts in all 3 West Coast states where they really pioneered mail ballots, and in Washington and Oregon, they are 100% mail, that even though participation, i.e. turnout, increases with the use of mail ballots, the number of ballots rejected because of alleged signature mismatches also goes up. One reason is that the people are making judgments not only aren't properly trained, but they're under stress to make these judgments very, very quickly, in a matter of seconds. But there are other problems that lie with the voters. Voters oftentimes think that all they are doing is affirming that they are the person that they say they are. And in some cases, I'm not sure about Florida offhand because I wasn't involved in this case, but sometimes there's not notice that you're supposed to, your signature is supposed to match what's on file on your voter registration, so that people are signing these sloppily, and it's their fault for doing it, but there's not a whole lot of notice. That's something that can be corrected administratively. It doesn't require a law to put a notice on the envelope. So there are things, and as I understand it, there were some 4,000 ballots that were rejected statewide because of signature mismatch. Some of those are going to be where you've got to, the spouse or the parent has signed it. Those can't be counted. I realize that. But many of them are, those are the people, those are the voters, and administratively, we really need to find a way to maximize the counting of ballots. There are other problems that took place. Apparently, there are almost 7,000 ballots that were not open because the post office failed to deliver them on time, even though they were postmarked before Election Day. There are many states, and I read a quote from one of the supervisors of elections who advocated this, that there just needs to be more time on mail ballots after the election for them to arrive. People are being disenfranchised because of the post office. I'm going to go through a few other things quickly before I talk a little bit about my federal case. Voting machines.
Chris, just so everyone knows, what we'll do is let's do a couple more minutes of you, and then we'll go to some questions, and the panel can interact.
Voting machines, we all know that Palm Beach had a lot of problems. They have antiquated machines there. They were burning up. Their optical scan. Out of the 67 counties, 64 counties have digital scan, which are newer, although some of those are already old and should be replaced. Miami-Dade also has, not totally, they have some digital, some of the old optical scan, and there's one other county, I can't remember which one it is. Those need to be replaced. I guess there's been discussion in Palm Beach, but they need to be replaced. The volume of work, and I alluded to this, in counties like Broward, Miami-Dade, and Palm Beach continues to lead to mistakes and delays in the tabulation of votes. And there are a whole bunch of reasons, but I think we have to be sensitive that these larger counties are under greater stress than some of the other counties. And again, I think if we think because we've gotten rid of Brenda Snipes, who I was no fan of either, her mistakes usually cost Democrats votes rather than Republicans. But if we think that things are going to be there'll be more transparency undoubtedly. I'm sure there will be a higher quality of workers from the top down, but they will still be under a lot of stress, and there will be problems, and we can't expect that Broward is going to be perfect in 2020 because we've gotten rid of Snipes. And finally, before I get to my case, the false claims of voter fraud are undermining our democracy, and it started at the top. Now the president, but during the campaign, Donald Trump began to talk about the election being fixed, and then in the days immediately, in the early days of the recount, the governor began to, the senator-elect, I guess, the governor, began to also pick up on that rhetoric, even after the law enforcement officials informed him that there was not voter fraud being, that their investigation turned up no voter fraud. And it really took a judge to admonish the parties, not singling anybody out, to turn down the volume, that happened. It's not really helping the public. It's not helping resolve elections for our officials to be talking that way. And I hope with a new governor who's I've been very impressed with in the early weeks in the way he's conducted compared to my expectations, I have to say, particularly in his most recent appointment for Secretary of State. I'm hopeful that that kind of rhetoric is not going to be present in the future. Now,
Hey, let's do this if we can for 1 second.
What?
We're hitting about.
Am I going too long? Okay.
Well, we're hitting about the 15-minute window left for questions.
Okay. I just wanted to say, give me 1 minute.
Well, here's what I was just going to
1 minute.
suggest, if I could.
What?
If I can suggest this. I have one question I want to pose to the whole
Okay.
panel, and then I want to give the audience an opportunity to ask questions. And And Chris, you mentioned something that leads me to this question on your discussion about mail-in ballots. And so let me just throw this out there to anyone who wants to answer. In 2017, Florida approved online voter registration. And as you probably are all familiar with, there's a number of projects going on around the country pushing automatic voter registration, pushing same-day registration and voting, and possibly online voting. And I'm just curious, when you look at those possibilities, aside for, let's take out of consideration the overseas online voting. So I'm talking specifically about in-state. What are some of the implications, some of the concerns that you have, some of the advances through technology that you think are worthwhile?
Well, I'm not a fan of online voting. I do think online registration is a good way to go. I am a fan of online voting for service members who are in combat. I think that, or in a war zone. I think that is very important. But other than that, I would move very slowly with online voting. Online registration, I think, is helpful. But I'm like everybody else. I think we've got to be careful that we're making sure that that people who are registering are qualified to register. So I don't really know where the state's going on that, but I'm somebody who believes that votes of qualified voters, we ought to figure out ways to make sure that they are counted. And I'm a fan of trying to make sure that as many people who are qualified to vote are registered, and that we remove barriers to registration. So that's my view.
All right, anyone else on the panel?
I share a extreme discomfort with the idea of online voting. I think the online voter registration system that Florida put together is a fairly effective and secure system that avoids some registration issues like data entry by local election officials trying to read someone's handwritten voter registration. If someone types it in themselves in a secure portal, then some of those sort of mistakes in the rolls can be avoided on the front end, I think.
Any other thoughts? All right, let me.
No,
go
I was just
ahead.
going to say,
Yeah.
the areas where you have the most evidence of fraud are in voter registration and in the collection of absentee ballots. You got a lot of documented cases here, and I think we need to be very, very cautious in expediting those areas or reducing any safeguards.
Let me make sure we turn to some audience questions, and if anyone's got a question, you can head to the mic here in the center of the room or just raise your hand and speak loud. And you're welcome to address a question to a particular panelist, and then, after he or she answers, someone else can jump in. That's fine. Yeah, go ahead.
Quick question. Thanks for the panel. This is a question for any of you that want to answer. You talked a lot about, it seems like the laws are pretty good, but if there was one change that you would suggest for the legislature to take a look at, what would be that suggestion of something you think that they should change in the law? Thank you.
One thing I would like to see them look at is the triggers for automatic recounts. In a lot of states across the country, we don't have automatic recounts. In fact, I was relieved, particularly after living this recount, to see in our runoff in Mississippi, at the end of November, that they don't even have recount provisions in Mississippi. So there was definitely not going to be a recount there. But I think we should really look at that. In our research, the largest margin that had ever resulted in a flip after a recount was 1,200. So here we were sitting at over 12,000 votes. I think some would say, and I would not disagree, that it was, disservice to the state to drag everyone through a recount with a margin that was never going to result in a flip of the election. So, I think having, currently the margin's at 0.5%. And that's a very large number of votes that historically is unlikely to produce any switch. So I think that's something I'd like to see us look at.
One, and it goes, I think, into something that that Chris alluded to, but maybe in a different way on the timing of issues and taking some of the time pressure off after the election, and it has to do with adding time on the front end before the election for canvassing boards to start the canvassing of vote-by-mail ballots. Currently, vote-by-mail ballots for a general election have to be mailed out by local supervisors of election no earlier than 35 and no later than 28 days before the date of the general election. But a canvassing board cannot start the process of canvassing and counting those until, I think, 14 or 15 days before the general election. There's a large number of voters that receive vote-by-mail ballot. They're super voters, they get it, they fill it out, they return it right away. So those ballots may be returned and sitting in the election official's office for a while, and if the canvassing board had the statutory authority in the same process that they use now to start the process of reviewing for signature matches, making sure that they're valid ballots, and then sorting them and categorizing them a week or two early when they start receiving them, that might be a way to eliminate the crush of ballots on and after Election Day, because there will be a large number that come in on Election Day or shortly before.
Well, I mentioned several areas, so I'm going to talk about one area that I didn't get a chance to talk about. There is a bill in the Florida legislature that proposes using digital ballot images for recounts and for sorting overvotes and undervotes. Digital ballots, 64 out of the 67 counties in Florida use digital voting. Automatically, when a voter puts his or her ballot, paper ballot through the machine, it creates an identical front and back image of that ballot. More than half of the supervisors in elections in Florida are destroying those ballot images. They should be put to good use and used in recounts like some states do. Maryland is one of them. And using those would narrow the focus of recounts and make them more manageable, as what happened in Maryland when they had two contentious, very, very close, truly close county executive races. They provided the ballot images to the lawyers for both sides. It narrowed the focus as a result and made the recount much more manageable. What would have happened in Florida, for example, is when the ballots went missing in Broward County, the 2,040 ballots, they would have been able to use those ballot images to determine what that real count was. Florida and other states in the country need to move ahead with the technology that we now have to make elections more transparent and more reliable.
Any other thoughts here?
Yeah, real quick. I also, ballot design is something we hear about a lot. And maybe we should consider, whether we should have some sort of we should certainly do research, polling interest groups and focus groups to figure out, what sort of ballot design does work. Not opposed to that. But, I think that if I might just rebut a little bit, we did a little bit of research. I mean, the last time Bill Nelson was on a ballot with a gubernatorial race, which was 2006, I think, by my count, he had the same, actually it was a bigger number of undervotes there. So, I think the ballot design argument, and I would never say to somebody who says they were legitimately confused, no, you weren't. I mean, I'm certainly that could happen, but it's also possible in this particular election that people just didn't want to vote for him, and that it wasn't a ballot design issue. So if we can have some sort of ballot review committee set up to eliminate this excuse, I would be all for that.
Christian, Kendall, any thoughts?
Well, Dr. Snipes, you recall, destroyed the paper ballots in a case and relied on the digital images instead and told the court, well, we've got digital images. We don't need the actual ballots. I'm a little uncomfortable with relying on digital images.
Well, I'm not suggesting that we rely on them. I'm saying it provides a backup. And by the way, what happened in that case, I happen to know, is that they did not preserve the ballot images, and then they contracted with a company to go back and take pictures of all the ballots again, and then destroyed the paper ballots. And they need to, there's a federal law that goes back to the 1960 Civil Rights Act that requires the preservation of all election materials for 22 months. And there's actually criminal penalties which could have been applied to Dr. Snipes for whatever reason they weren't, for the destruction of those paper ballots. But both the paper ballots and the ballot images should be used, and the ballot images are a great tool for making these recounts more manageable and confronting, frankly, losers with the reality that they're not going to win, that these 30,000 votes are not ballots that were missed by the machine. These are undervotes, and you're not going to win this recount.
I like the laws pretty much in Florida. I actually think the recount laws are clear. They make it easy. We knew where it's going. If you've looked at the regulation that provides standards for counting the ballots, I think they're really good. I don't know who drafted them, but they make it pretty plain when you're going through optical scan recounts what you're supposed to do. I think it was a failure of local administration. And how you cure that? I mean, obviously Miami-Dade, the mayor was embarrassed after 2012. He got everybody in gear, and they did it right and did it well. That could happen anywhere. How you fix it going forward, I'm not sure, but I agree with the comments about as much oversight as possible from the Secretary of State. Traditionally, they've been deferential to local officials, but I think we're seeing that probably, although I'm reluctant to say it, more guidance from Tallahassee is very, very important, because between elections, most local governments don't pay enough attention to improving things. As far as ballot design is concerned, I think both parties have an opportunity to review the ballot design, don't they? And so if, one side, maybe my side, is asleep at the switch, that's unfortunate, and that's a mistake. So how do you fix it? You pay a lot more attention going forward.
All right, anyone else have a question? All right, I've got a last one. You can give a thumbs up or thumbs down to this one if you want. But this fall, North Dakota adopted a amendment to its constitution that provides for citizen-only voting. As you may know, in a number of local elections and potentially in any state-only election, you could have non-citizens vote. So I know through Florida's Department of State, there's a ballot initiative that is beginning. And I'm just curious whether you think there's any need for Florida to adopt a citizen-only voting amendment.
I testified to the House Judiciary Committee last summer about citizenship issues. We're litigating a lot of cases around the country about citizenship, citizens on the voter rolls. Dr. Snipes admitted in depositions that aliens are voting in Broward. It's non-citizens, not people from up there. I was testifying in this House Judiciary Committee about how we can improve the voter rolls to keep citizens off the voter rolls, and a representative from Maryland said, I think non-citizens should be allowed to vote in federal elections. And I thought, oh my gosh, how far we've come. So there was an organized effort, a law reviews of mobilization to get federal law changed. Now look, it's a long-term deal, it's not happening in this Congress, but to allow non-citizens to vote. After all, they drive on the roads, they go to the schools, they receive the services. Why shouldn't they have a voice? So goes the argument.
I like citizens-only voting.
I feel the same way.
Yeah, I think our election administrators have enough issues to deal with without having a separate category of voters on the rolls who are eligible to vote in local elections but not federal elections, and it just seems like a recipe for real problems.
Yeah, and I think, just real quick, I think, in the vein of things that aren't reported when they perhaps should be, I mean, we've all seen that the Supreme Court is wrestling with this issue on the census, whether citizenship should be properly asked. And yes, the question, that's been proposed now is phrased slightly differently, but on the census, I mean, there always have been questions regarding citizens, whether somebody, unnaturalized, I believe is the word they used, have been living in the residence. So, this is not new territory. This is something I feel like we have protected in the past and should protect in the future.
Well, we've come to our end of our time. You can obviously come and talk to these panels some more. Now, you may have noticed the title of this was Election Law and Something Else that we never got to. So I've heard that Daniel Woodring is going to have a fireside chat this afternoon on redistricting. So you can join him in the lobby. Thank you, our panelists.